I'm Wendy Netter-Epstein, a law professor at the DePaul University College of Law. I'm so thrilled to have with me today Professor Zachary Clopton of Northwestern's Pritzker School of Law. Professor Clopton is DePaul's inaugural Clifford Scholar in Residence, so let me thank the Clifford Law offices for making this possible, and of course, thanks to Zach for being here. What we have planned is a bit of a fireside chat today. We're doing our best in these pandemic times, so thank you for humoring this setup. I've obviously got my fire going on my end, and Zach, you've got that beautiful fire mantle behind you, fireplace mantle as well, on your side of the Zoom divide. So we're going to see where this chat takes us, but I plan to ask Zach about a variety of topics, from what he sees the role of a law professor and scholar being during these times to some of his views on current issues in civil justice. I do want to give just a little bit of a bio for Zach. The full bio will be posted. It's incredibly impressive, but I'll just note that he, prior to entering academia, was a clerk for the Honorable Diane Wood of the Seventh Circuit, an assistant U.S. attorney. He was in the national security practice at WilmerHale. I got all that right so far, right, Zach?
That's right.
Yeah. A prolific author in both law reviews and also in popular press. So Zach, you really are a prolific writer. How do you choose what topics to write about?
Well, first of all, I just wanted to say thank you to you, Wendy, for doing this, to DePaul Law School, and to the Clifford Law offices for such a great honor. I'm so excited to be part of the Clifford Scholar in Residence program.
We're thrilled to have you.
Well, it's great. It's great to be here, virtually at least. And so, to your question about writing, one thing that is great about being a law professor is that we have a lot of freedom to choose what we want to write about. And so I choose to write about the things that are interesting to me. Now, a big part of that is things that I think can have an impact on the actual practice of law, on the actual public policy of the United States. And so for me, that means thinking about big questions like how we resolve complex disputes, questions like whether cases should be heard in court or in arbitration, in a single one-on-one litigation or in a mass litigation like a class action or a multi-district litigation. But all of that is in service of the bigger question: how do we solve the hard problems that we're facing as a community and a country?
If part of your goal is sort of to influence policy and to act as an advocate, when you're choosing where to publish your writing, how do you decide where to focus those efforts?
So I think that I have a few different audiences that I try to speak to. So one certainly is other law professors and judges and lawyers and those who have the misfortune of reading 75-page law review articles. But I think that work is really important because that's the kind of intellectual groundwork that needs to be done before I feel comfortable making an argument in the popular press, for example. So that's part of my audience. But I also look to try to translate these ideas to broader audiences. And I do that in newspapers and magazines and online publications. I've done it through amicus briefs in courts, and I've done it through policy papers circulated to legislatures and executive agencies. And really, the way I kind of go about deciding where a particular piece of writing fits is going to be about what I'm trying to accomplish. So if the goal is to achieve a change in regulation, then the natural audience would be an agency. If I want to influence judges, it would be a court. And if it's something where I think there should be a broader popular movement, then I look for opportunities to speak to those audiences.
How effective do you think law professors can be in those endeavors? I mean, there's a criticism generally about those who can't teach. But at the same time, obviously, we are engaged in all of these enterprises where we are trying to make a difference. So can we do it? What do you think?
Can we do it? Absolutely. It's hard work. Policy making is hard work. And so I don't have any illusions that I'm going to go and move mountains. I just want to do my small part. And what I think that means in a lot of situations is I have the time and the resources and the excellent research assistants to take on tasks that sometimes policymakers or judges or practicing lawyers don't have the time or bandwidth to do. And I hope that that little contribution can help move that ball forward in policy reform.
Wow. Well, I'm biased on this, but I certainly think that it can. And I've seen your name on all the amicus briefs that you filed, and I know that you do consulting work and trying to influence rulemaking and legislation, and that seems like incredibly important work. I did want to ask about your sort of role as a public academic. There's a lot of discussion now about how everybody's sort of living in their own echo chambers. So if you're somebody who holds views that are more so left of center, you're going to be reading media where other people who hold similar views are going to be giving their opinions, and social media is going to be filled with people that hold similar opinions. And sort of same thing if you have right of center views, that you're only going to be interacting with other folks that have those similar right of center views. Is this something that you think about as a public academic, or something that you're concerned about? And I suppose the $1,000,000 question, which probably is an unfair question, is, but what should we be doing about it?
Yeah, it is. It is something that I think about. And my not $1,000,000 answer is you just have to try your best. One thing I like about writing about issues like civil procedure in federal courts, and I have the same experience teaching, is that even though these issues are deeply political in the sense that they address issues that matter to the polity, they don't have the same flavor as something like abortion rights. When I walk into my civil procedure class and teach the standard for summary judgment, my students don't come in with preconceived notions about what the appropriate standard is, whereas I suspect they do when they walk into their constitutional law class to talk about Roe versus Wade. Now, part of what I try to do is explain to them that actually summary judgment is political, and that there are big value judgments that go into what we think the appropriate standard is. But because we're starting in this at least seemingly more neutral place, I think it does take the temperature down a little bit. And I often find it's easier to have conversations with people who might disagree with me on partisan politics when we're talking in the language of procedure and courts and jurisdiction.
So, just a small pivot away from your work on sort of more public-facing venues, I want to discuss, and you've already touched on this, but the value of traditional legal scholarship. So, a little bit of a personal anecdote is that since we've been holed up in the house and I've been working remotely, my middle school age children have had sort of this ability to see what my workday looks like a lot more than they did before. And I think before COVID started, they would have told you that my primary job was teaching as a law professor. And certainly teaching is a very important part of what we do. But I think they would say that they've been very surprised to see the degree to which my day is writing projects and the amount of time that I spend on writing projects. And I know you are so prolific in writing in law reviews and must spend tons of time writing for law reviews. What do you say to critics who argue that writing for law reviews, which admittedly have limited readerships, isn't worth it?
I hope that there are people out there who are reading my law review articles and your law review articles. I'm reading your law review articles, so you at least have one reader out here.
Great.
I guess I would say a couple things. So one that I mentioned already a little bit is that sometimes you need to write the 100-page treatise before you can write the 800-word op-ed. And that I don't expect the general public to read my law review articles, but I often find that I learn a lot in the process of writing them that allows me to be a better communicator about the things that I care about. So that's one part of it, is that you can imagine a pyramid, and we start at the bottom with our big law review article, and then we convert it slowly but surely into a message that we can send out to the broader public. But the other thing I would say is that the law review articles that you and I and our colleagues write, they inform what we do in the classroom. They are read by students and lawyers, maybe not hundreds at a time, but they are read by people who are deeply involved in the litigation world, in the public policy process. And so even if the readership is small, if it's a small readership that's engaged in the issue, then that's a pretty good outcome, I think.
Yeah, I would agree. I wonder if you could say a little bit something more for our audience who are not academics about the process of actually getting to a final law review article. Because it's not just us holed up in a room on our computer, although, of course, that is a component of it. But maybe something about the workshopping process and how our final law review articles are actually formed.
Sure. The first thing I guess I would say is I was thinking about your description of what your kids must think about your job, and I have young kids, and they're similarly staring at me all day. And I guess I haven't asked them, but I imagine one thing that they would be surprised by is how much time I spend reading. That so much of the process is the reading of other people's work, the reading of cases, if you're writing about cases, legislative history, of other disciplines, economics, political science, history, whatever it is that informs your work. And so we spend a huge amount of time reading before we even begin the writing process. And then, at least in legal academia, there's a very strong culture of presenting work that is not complete. In fact, it's unusual to go to a conference or a law school workshop and hear someone talk about a paper that's already been published. The idea being that you can actually get a lot in many cases out of sharing your work with other smart people, some of whom work directly on the topics you work on, other people who work on adjacent or even uh, further adjacent legal issues, thinking about the ideas, talking them through, and working on refining the ideas and refining the explanation of those ideas. The other thing that is kind of unusual about law review publication is that unlike most disciplines, legal scholarship is published primarily in student edited journals. And you often hear criticism of the delegation, in a way, of the legal scholarly work to law students. And I think there are good arguments on both sides, but the students that I've worked with on my articles, including a number of students at DePaul Law School, have just been fantastic. They take the job very seriously. They think very hard about what they're doing, and they often provide some of the best feedback, both about the substance, but also about the style. Again, about communicating ideas, not just to the five other law professors who are working on the same topic, but to educated lawyers who are interested in what you're doing, but may not have spent the last 10 years reading all of the cases that inform a particular article.
Yeah, it's an imperfect process, but the students really are working so hard and adding so much value to our work. And, I think we're both probably very appreciative for that work that they do put in. Um, I wanted to ask you, you recently published an article with a number of co-authors in Science Magazine, which is not a normal place that law professors are frequently publishing. But it's called How to Build a More Open Justice System. And in it, you and your co-authors talk about how opaque our court system can be. I'm wondering if you could just, talk a little bit about why it's so hard to access public court records. And incidentally, our state court in Chicago is a big offender in terms of making it difficult to access records. And maybe a little bit about why, what you think could be gained from making it easier to access public records.
Sure. So this paper came out of a large collaboration that's housed at Northwestern University, although has collaborators outside of Northwestern. And it's a group that we're now calling SCALES, which is an unwieldy acronym if I gave you the full name, but we'll just say SCALES. And it involves law professors, computer scientists, data scientists, members of the journalism school, and many other folks working together on this project to try to open up court records. And I just have to say, it's been such a pleasure to work on this project. It's great to get out of the legal bubble and work with folks outside of it. And one thing I find so invigorating is talking to the computer scientists and the data scientists and explaining to them that if you want documents from a federal court case, even an important federal court case, you have to go onto this system called PACER, or CMECF. You have to use this kind of outmoded software, and then you have to pay per page to download it. And the indignation from the computer scientists and the data scientists that that's how you acquire court records, as I said, it was really invigorating. And so we applied for and got a large grant from the National Science Foundation to essentially build, and I'm doing none of the building, by the way, but build software that can analyze and communicate information from court records. So we purchased huge amounts of court records, federal court records, and then the data scientists and computer scientists are building these algorithms that will allow you not only to get the piece of paper from the case you want to hear about, but to ask questions in natural language, like how often are criminal defendants convicted in Chicago as compared to Atlanta on charges of burglary? And once this work is done, it will say 75% versus 30%, or whatever those numbers are. And so the article that we wrote for Science tried to say a couple things. The first is that there's a strong value in openness, in transparency, and that court records, including the state court records you mentioned, the federal court records I mentioned, should be free and accessible. But second, just making them free and that such that you could download them to your computer doesn't actually make them accessible and transparent, that there's additional work that needs to be done to translate them. So one thing we talk about in the Science article is the process called a petition to proceed in forma pauperis, or IFP, which is essentially asking for a waiver of the filing fee in a civil case. And so you could go and you could look up a case and find out if someone applied to proceed IFP and find out whether that petition was granted or not. But that doesn't actually tell you very much about the legal system. But what we can do with our software is we can look at all of the IFP cases for 2016, for example, and we can tell you what the grant rates are in different places around the country. And we can tell you whether the grant rates vary within any given courthouse, depending on which judge you get. And it's only when you have this large amount of information that you can actually think about the kind of policy reform that I think is really important in this area. And so the piece in Science also made this pitch not only for transparency, but also for usable transparency, getting the data out there in a way that we can actually think about it and make decisions based on it.
So you're somebody who's done a lot of quantitative work, and this Science project in some ways is laying a platform for being able to do additional quantitative work in the future. And this is something that we're certainly seeing more of in legal academia, but it's not something that historically law professors, at least in my opinion, have done enough of. We tend to spend a lot of time thinking about theoretical questions, which is valuable, but not necessarily based on good information. So what do you see as sort of this interplay between professors who are doing more theoretical work and those who are doing more quantitative work? And what's the pitch for why quantitative work is necessary?
Sure. I'm very much in the all of the above camp, that I think legal questions require some understanding of the world. We want to know how many cases look like X versus look like Y. But I would also say that I think the most interesting and probably the most important questions in law are not quantitative questions. They're normative questions. They require value judgments. They require theory, as you said. But we want to have those debates with a good understanding of the world around us. And so I think there are kind of obvious synergies between people who are doing quantitative type work, trying to explain the world, explain the causal relationships between different aspects of the law or of society, and then people thinking the big picture questions about what to do with that information.
It's an interesting time to be having this conversation because science and data seem to be very much under attack in our society. And there is, I think, a growing skepticism, some of it probably healthy and some of it not, about how reliable and trustworthy science and data are. What do you make of all of this?
Yeah, I mean, I think part of it is a broader questioning of expertise. And I think, like you, my reaction is some of it is warranted. Sometimes we need to question people who assert expertise. But that doesn't mean we should throw the baby out with the bathwater. And I think that good, solid work, whether it's kind of quantitative empirical work or theoretical work or any of the kind of academic work we're talking about, is important in thinking about how we want to govern our society, how we want our courts to operate. And I think it's too easy to cherry pick a few examples of bad science and then paint with a broad brush. That really, for the most part, if we build systems to do this work, evaluate the work, and then update our beliefs as we learn more, that's the best we can do.
And probably it would help if we were doing more replication of studies and verifying. I do a lot of work in behavioral economics, and one of the criticisms has been that people are putting too much weight on these one-off studies that nobody has actually tried to replicate and haven't tried to run in real-world scenarios. And so I think to the extent that we're able to do more of that, it also helps people have more confidence in outcomes and in the data that they're basing decisions on. I don't know if you agree with that or not.
Yeah, I think that sounds right to me. I mean, I know in these kind of replication debates, there's both the kind of direct replication, you run the same study again in a different population, and there's also what sometimes is called conceptual replication. So it doesn't need to be the exact same study, but if we see that there's a certain type of bias that exists in all sorts of different situations and with all sorts of different people, then the fact that any one particular study can't be replicated doesn't, to me, undermine the bigger point that we're trying to learn from this work.
All right, let's switch gears and talk policy for just a little bit. So the biggest story of the past couple of weeks has obviously been the disaster in Texas after those unprecedented winter storms wreaked havoc on the state's energy grid. There's a lot of debate about whether or not that was fueled by climate change or not, but it does seem clear that climate change is one of the biggest problems facing the world right now. You wrote an article called Civil Justice and the Green New Deal that you published in the DePaul Law Review as a part of one of our annual Clifford symposiums. And in it, you talk about one way in which the Green New Deal is not actually yet like the New Deal from which it gets its name. And the Green New Deal bill, at least at this point, doesn't employ civil enforcement mechanisms. Can you tell me more about that and why you think that might be a problem?
Sure. And I should say that although the Green New Deal made for a nice name for the article, setting up this contrast with the New Deal, I think these points are relevant to any approaches to environmental problems, whether we want to call them Green New Deals or otherwise. And the big point that I tried to make in the article is that if you think about the New Deal and the courts, the common narrative was that the New Deal set up a conflict between the New Dealers and the Supreme Court. And you might think that the New Dealers were hostile to the federal courts. And maybe that was true at the level of constitutional law in the Supreme Court. But if you look kind of underneath the hood of the New Deal, what you see is that in statute after statute, the New Dealers were relying on courts as part of a broader way to enforce federal law. So when provisions about fair labor standards or about communications technologies or about the regulation of securities were put into the US code, there needed to be a way to enforce those provisions. And often those methods of enforcement involved the courts, either through private lawsuits, sometimes called private enforcement, or through public lawsuits. The federal government or state attorneys general would bring cases in federal or state court enforcing these federal statutes. And the United States, more than most countries, relies on private enforcement, relies on the courts as a way to turn regulation into actual enforcement action. And so kind of building on that idea, I turned to the reforms that fell under the label of the Green New Deal. And one thing I noticed is that most of the proposals for Green New Deals said very little about how these reforms would be enforced in practice. And to me, the right answer is the same answer in the New Deal. It's turning to the courts. It's turning to a mix of private and public enforcement, often overlapping private and public enforcement. It means thinking about rules on jurisdiction, on arbitration, on the procedure in these cases, because those rules are going to have direct consequences for the level of enforcement. So you not only need the substantive standards, but you also need to think about where the cases are going to happen, who gets to bring them, and under what procedural rules.
So, what would a private right of action look like in enforcement of a Green New Deal sort of environmental reform law?
Sure. So many of the major environmental laws already on the books rely on private enforcement, the Clean Air Act, the Clean Water Act, and the like. And in fact, when there were earlier efforts to use the Clean Air Act authorities to deal with climate change, in a sense, through regulation, the EPA was going to regulate climate, but the enforcement of those regulations was going to fall to private enforcement. One way to think about it is any standard that you want to put in the law where you want a mechanism where violators can be punished could be handled through public enforcement, could be handled through the EPA sending out their investigators and seeking sanctions against violators. But it just as easily could be delegated to private parties. And private parties will pursue these cases because they get damages or because their attorneys get attorney fees. And so things like whether there's an attorney fee award is an important lever that legislators can pull when trying to set the level of enforcement.
Yeah, and of course, we always have this concern when we include a private right of action in a statute that it could open the floodgates and overwhelm the courts. And on the other side, you have a concern that the government resources that are available to actually enforce the law are insufficient to accomplish the goal. So I assume you consider sort of these trade-offs in any legislation that would be adding a private right of action or civil enforcement mechanisms. Yes? No.
Absolutely. And again, I think one way to conceptualize these choices is, again, that they're different ways of calibrating the level of enforcement. You can do that by increasing or decreasing the size of the fine, but you can also do it by increasing or decreasing the likelihood of enforcement. And so one way you can do that is by opening or closing courthouse doors to private litigants. One big advantage, by the way, of relying on private enforcement or often kind of overlapping public and private enforcement is that it helps deal with the possibility of blind spots. If you're concerned that government regulators can be captured by certain industries, or that they have friends outside for whom they want to do favors, well, the private plaintiffs aren't captured in the same way. And so having this overlap means that if the government enforcers are pulling back, perhaps unjustifiably, then we should expect the private enforcers to step in and fill the gap.
Zach, you're an expert in class actions. This is just a very broad general question, but I'm wondering if you could share some thoughts with us on how important you think class actions are to civil justice.
Sure. So the class actions are a big topic. I'll just mention two kind of places where the class action is, at least to me, particularly important. So the first is the class action seeking often injunctive or declaratory relief, where the kind of classic example are the desegregation cases. Indeed, that they were motivations for reforms in the class action rules. And so here, where you have often government actors treating whole classes of people in a certain way, often in a certain and unfair way, then it only makes sense that when we seek to use the courts to reform those policies, we want to proceed not on behalf of one person who wants to integrate a school, but on behalf of the whole class who is treated discriminatorily. And so the class action is a mechanism to respond in a way to discriminatory treatment that itself treats a group of people as a class. So there's a kind of one-to-one ratio there. The other area where class actions are really important is in these areas where we have people who are harmed maybe a small amount individually, but in the aggregate harmed a lot. So I like to give this example to my civil procedure students, that imagine that you work for a big telephone company and you have a brilliant business idea, which is that you're just going to increase every customer's cell phone bill by $1 per month. You're not going to tell them you're going to do it. You're not going to provide any additional service. You're just going to tack on $1 and hope that they don't notice. And you have millions and millions of customers. So you're making millions and millions of dollars per month for no benefit. And if you think about any one consumer, it's not even worth likely that person's time to call up the telephone company and complain about the $1 charge, let alone going out and finding a lawyer, paying that filing fee to get into federal court, paying the lawyer to litigate the case to recover your $1 per month. Yet as a society, we think it's a problem if telephone companies can randomly add $1 charge to millions and millions of people's cell phone bills every month. The class action is, in a way, a response to this type of behavior. It says this is a problem not just for Zach's cell phone contract or Wendy's, but for all of us. And we are here, again, kind of delegating to plaintiffs, often to plaintiffs' attorneys, to go out and remedy these wrongs. And so class actions are going to be really important as a response to these kind of low value but widespread actions on the part often of large corporations.
So, as a contracts professor, you're going to have to permit me this question, but over the last several years, the Supreme Court has done a lot to sanction mandatory private arbitration. And I don't want to get too much into the weeds of the cases or anything like that, but I'm wondering if you could talk a bit about this issue and whether you think class actions are going to lessen in importance or already have lessened in importance because of those decisions.
Yeah, absolutely. And so the Supreme Court has taken the Federal Arbitration Act, a statute that's almost 100 years old, that was not designed with these kinds of consumer disputes in mind, and turned it into a very powerful weapon. It's a powerful weapon both in that it can cut off court access for plaintiffs and often for classes of plaintiffs, but also a powerful weapon because it can strike down state laws that are seeking to regulate some of the behaviors that you and I have been talking about. So mandatory arbitration is a major impediment to civil justice. But there's a but, and maybe this is the optimist in me, but there's a but for a few reasons. So the first is, I think, and in large part, I think, due to the Me Too movement, there has been growing attention on the problems of mandatory arbitration. Both the problems with respect to these kind of class action and civil justice issues, but also with respect to issues of confidentiality and wrongdoing. And so I think there has been growing attention on this. The FAIR Act has been making progress in Congress. I'm not sitting here today predicting that it will pass, but I think it is more likely to pass today than a similar bill would have been 5 years ago. There's also more interest across executive branch agencies to seek to regulate arbitration in ways that are not inconsistent with the Federal Arbitration Act, but might cut back on some of the things we've been talking about. And lastly, something that I have often thought about is that even if there's an arbitration clause that binds, say, an employee or a consumer to go into arbitration and says that they can't pursue class-like relief, that arbitration clause says nothing about what the Attorney General of Illinois might choose to do, what the Justice Department, Federal Justice Department might choose to do. And so I think here is where the kind of overlap between public and private enforcement is very important. That if arbitration and mandatory arbitration is making it more difficult to pursue private enforcement, well, this is exactly the sort of area where a public enforcer, again, a state or federal attorney general, might want to dedicate resources. Because, of course, the state of Illinois or the United States of America are not parties to the cell phone contract between me and my cell phone provider.
Yeah, interesting. But see our prior conversation, right, about limited government resources and what cases the government might have the ability or the desire to take on. But that's definitely something interesting to think about. So this is probably an unfairly broad question, but looking ahead and as you're thinking about your own research agenda and where you want to put your effort and your energy in terms of advocacy, what do you see as the biggest emerging issues in civil justice, particularly in light of the pandemic, but also otherwise?
Sure. So obviously the pandemic is front of mind for all of us. And I do think there is going to be an important role for courts in thinking about how to move forward from the pandemic. There's already ongoing litigation about insurance coverage related to the pandemic, for example. There may be litigation around vaccine distribution. There's been litigation around state and local restrictions in light of the pandemic. And these are all really, really important areas that I will say are a bit above my pay grade. On the kind of broader question of civil justice, one of the most important issues is the one you just brought up, I think, which is about mass arbitration, mandatory arbitration, and the regulation of it. And I think there's important roles for policymakers at the federal level, the state level as well. There's important roles for lawyers in thinking about those issues. The other, and also one you brought up, I think, is climate. For better or worse, lawyers get involved in all of the biggest policy issues facing the United States. That was true when Alexis de Tocqueville said that, and it remains true today. And so I think we will continue to have an important role for lawyers and law in response to climate. And climate is not just an environmental issue. It's a justice issue too. And so there again, as we think about issues of environmental justice, there's going to be an important role for lawyers and courts in thinking about how to respond to those events.
I think that's a great place to end our fireside chat with Professor Zachary Clopton. Thank you really for all of the terrific work that you're doing and for sharing this time with me and with our broader community. Thank you also to our viewers for tuning in.
Thanks so much.